Hi everyone, let's talk about product liability. In this lesson, we're going to define product liability. We'll examine when businesses might be liable for harm caused by a product. We're going to examine the liability theories of negligence, misrepresentation, and strict liability. We'll describe various defects that can give rise to a product liability lawsuit, and we'll examine some defenses to product liability claims. So to get started, product liability is the liability that manufacturers, sellers, and others have for injuries caused by defective products. When something goes wrong with a product and somebody gets hurt in some way, we're going to have to find out who is liable, if anyone. The three main theories here are negligence, misrepresentation, and strict liability. So looking at negligence first, in order to prove a negligence claim successfully, the defendant, I have to show that the defendant is at fault for causing the plaintiff's injuries. The plaintiff must prove that the defendant has breached some duty of care to the plaintiff and that harm was caused as a result of that breach of duty of care. Only a party who is actually negligent is liable to the plaintiff in a negligence lawsuit. That will make more sense when we talk about strict liability, when people who aren't negligent could actually be held liable. So a failure to exercise a duty of care includes the following things, among others, but failing to assemble a product carefully, negligent product design, negligent inspection or testing of a product, negligent packaging, and failing to warn of the dangerous propensities of a product. An example is Belinki versus Ryobi Technologies Incorporated. For those of you who aren't aware, Ryobi is a house brand that's sold in Home Depot stores. They don't manufacture their own products. They have third parties manufacture them. They put their name on it and then they sell them. And I say that because that'll become part of the lawsuit. But the basic idea is that a man named Frank Wright purchased a Ryobi riding lawnmower, and his wife was inside the house. She heard a noise. She looked outside. The mower and her husband were both on fire. Mr. Wright actually died as a result of this, which is very unfortunate. So the administrator of the estate sues Ryobi Technologies for product liability. So in order to successfully prove this, we're going to have to prove that Ryobi breached a duty of care. So what the plaintiffs are alleging is that Ryobi knew that there was a design defect in the mowers where a fuel line would leak fuel onto a hot surface of the mower, which would cause it to catch on fire. Ryobi claims they were not aware of this. However, in court, they were able to successfully demonstrate that Ryobi should have been aware because there had been previous cases. Ryobi then also claimed that they shouldn't be held liable because they weren't the actual manufacturers of the product. It was actually a third party called Husqvarna who was manufacturing the mowers. So the court did not look very favorably upon that argument either. They basically said that if you as a company are putting your name and your brand on a product and selling it, it's assumed that you're claiming it and that you can be held liable for it. So during the trial, the court ultimately determined that Ryobi, number one, they were aware of the defect and they didn't do anything to mitigate that or to warn people about it. And two, that they are liable because they had their name on that product. So they were ultimately liable. And I think the judgment was $2.5 million to the estate of Mr. Wright. Next, let's look at misrepresentation. Misrepresentation is when we say something false about a product. So intentional misrepresentation occurs when a seller or lessor fraudulently misrepresents the quality of a product, and then or maybe even they conceal a defect. So both could be intentional, outright stating something that's false, or taking steps to conceal something that they know is wrong so that people don't know about it. So recovery is limited to persons who were injured because they relied on the misrepresentation. The third theory that we talk about is strict liability. So one major thing to point out here is that North Carolina, for product liability cases, does not recognize strict liability as a cause of action. The main idea behind strict liability is that if somebody is harmed by a product, not only can I hold the manufacturer liable, but I can hold the distributors, the wholesalers, the retailers, whoever else is in that chain of distribution of a product could potentially be held liable, even if they didn't do anything wrong. So in North Carolina, like I said, we don't necessarily recognize that, but strict liability is recognized in a lot of states. So that's why we mention it, so you're aware that whichever state you're doing business in, you have to be aware of the particular laws of that state to be aware of what kind of liability you might have. There are some limitations to strict liability when states do recognize it. Casual sales by non-merchants won't be subject to strict liability. It applies to products and not services. And if there's a mixed transaction, we would have to go in and determine which is the dominant element. Would it be the product or the service? That would let us know whether or not we can use strict liability. I'm going to move through strict liability relatively fast just because we don't apply it in North Carolina, but I do want you to be aware of it because it's a major topic if you're in another state. And a lot of you, I'm assuming, are going to move out from here and go to other states. So under strict liability, all the parties in a chain of distribution of a defective product can be held strictly liable. In other words, even if they didn't do anything wrong. The idea behind strict liability is that we protect the public from dangerous products, saying that it puts a greater burden on everyone in a chain of distribution, saying even if we didn't do anything wrong, we could be held liable. So the theory being that everybody would be a lot more careful to make sure they're selling safe products. Whether that works out in the real world, it's hard to say. So a party who can recover for strict liability is a person who is in privity of contract between the plaintiff and the defendant. Even if somebody is outside of privity of contract, they can still recover under strict liability. So an example of this might be if I buy a defective product and I'm not harmed by it, but I invite somebody over to my house and they're harmed by it. They didn't buy the product. They weren't in privity of contract between me and the seller or the retailer. But since harm happened, strict liability could still apply. So a consumer who purchased a product and any user of the product can recover. Even third-party bystanders are entitled to the same protection as the users are. Looking at negligence and strict liability in graph form, you see on the left side of this graph here, if there is a defective product, we see a direct line between the consumer filing a negligence lawsuit against the manufacturer, the person who negligently manufactured that defective product. On the strict liability side of the graph, you can see that the consumer can sue the manufacturer, but they can also sue the distributor, the retailer, whoever else is in that chain of distribution. That doesn't mean in North Carolina you can't win a product liability suit. It just means it's harder to sue somebody, especially a retailer who wasn't aware of the defect or a wholesaler who wasn't aware of the defect. You'd mostly be going after the manufacturer unless you can somehow show that the other parties involved were aware of or should have been aware of the defect and didn't do anything about it. So the damages recoverable for strict liability vary by jurisdiction. The damages for personal injuries are recoverable in all jurisdictions that adopted the doctrine of strict liability. Property damage is recoverable in most jurisdictions. Economic loss is recoverable in very few jurisdictions. And punitive damages are only awarded if the court finds the defendant's conduct was committed with intent or with reckless disregard for human damages. And that's true with a lot of punitive damages instances. We really have to show that somebody did something intentionally wrong or recklessly wrong to get punitive damages awarded. So looking at product defects, and we're still looking under strict liability here, but we're showing that something was wrong, inadequate, or improper in the manufacturer, design, packaging, warning, or instructions about a product. Now, if I'm suing for negligence, I just have to show that not only was something wrong, but that the manufacturer was aware of it, or they should have been aware of it, or they didn't test it properly, or something happened. The manufacturer was negligent in some way. If I'm suing for strict liability in a state other than North Carolina, I don't even have to show that. I just have to show that injury caused and that there was a defect that existed, and I can potentially get an award of damages. A defect in manufacture happens when a manufacturer fails to do several things, or one of several things. They could fail to assemble a product properly, they could fail to test a product properly, or they could fail to check the quality of a product adequately. So this would be true in both negligence or strict liability lawsuits. If we can show that something happened and went wrong in the manufacture of a product, and that caused it to be dangerous or malfunction and cause harm in some way, then that would qualify as a defect in manufacture. An example of this is the Shoshana Coca-Cola Bottling Company versus Delinsky. Now, this is an interesting case. A man bought a bottle of Squirt soda, which I don't know if we have around here in North Carolina, but it's popular in other regions around, and much more so, back in several years ago. But he bought a bottle of Squirt soda, and after drinking it, he immediately became ill. And when trying to investigate why, we later found that there were the remnants of a dead mouse inside of that bottle that caused him to become sick. So Delinsky sues, and he bases his lawsuit on the theory of strict liability. Now, Shoshana counter argues that they followed all their normal safety protocols, and that they didn't do anything wrong. It was just a freak accident. And they also say that they think that the mouse might have been added later, not due to their own mistake. So during the court process, an expert toxicologist came in examining the bottle, and his opinion was that due to the state of the bottle and the stuff that was in it, it looked like the contents, or at least the mouse contents of the bottle, were there before liquid was added, so it happened during the bottling process. And under the strict liability theory, even if we can't show that Shoshana did anything wrong, harm was caused because of a defect, and thus they can be held liable. And that's what the court decided, was that since the expert testimony decided that, or at least convinced the court that the mouse was in there before Delinsky got a hold of it, and while it was still under the control of Shoshana, then they can be held strictly liable, even if we can't show that they necessarily did anything wrong in that instance. Sometimes defects can be a result of design of a product. And some products are just going to be dangerous no matter what we do. So, knives are designed to be sharp and to cut things. So that can obviously cause harm. But when we're looking at how adequate a product's design is, and if there's a defect, we have to examine multiple factors. So one of those is a risk utility analysis to look at the adequacy of a product's design. So the court might consider, well, what is the gravity of the danger posed by the design? In other words, how serious is the danger? Could somebody be actually seriously maimed or killed? Or is it just something that might cause somebody some inconvenience? What is the likelihood that injury will occur? What is the availability and cost of producing safer designs? Maybe it's possible to produce a safer design, but that might make it so expensive that nobody would be able to sell it or buy it. What is the social utility of the product? How valuable is this to society? How often do we need to use these things? And then the consumer expectation test requires showing that the product is more dangerous than the ordinary consumer would expect. So these are things to consider when trying to evaluate whether or not there was a defect in the design. So in my example of a knife, knives are sharp and knives can cause harm, but would there be is there something about the design that would cause the handle to shatter, or that would otherwise cause the knife to be more dangerous than it really should be, and that could cause harm that, everybody expects a knife to be dangerous, but even an ordinary person handling it like they would a normal knife, would they be more likely to be harmed? And if so, we might have a defective design. An example case for defect in design is Genie Industries versus Matic. This happened in Texas in 2015. The facts of the case are that a church hired an electric company to run some electric cabling through their ceiling, and the men were using a Genie AWP-40S lift to do the work. To give you an idea of what we're talking about here, I'll just show you a picture. You've probably seen these kind of lifts before, where somebody steps into the platform lifts up high so you can do work, and then before you lift the lift up, there's these little things called outriggers that extend out from the base to stabilize the lift so that it doesn't tip over. And there are warnings all over in the manual and right on the product saying it's very dangerous to try to move the lift or to have somebody up on the lift if the outriggers are not extended. And the men had been fully trained on how to use the lift properly. Regardless, they started doing the work, and they started off using it properly, but somewhere along the way, they decided to, rather than coming down off the lift, retracting the outriggers, moving the lift, and then going back up, they would just leave the man up on the lift, retract the outriggers a little bit, and then try to move it with him still up at the very top. Now, the predictable thing happened. The lift tipped over, the man fell down and died as a result. They sued the church, they sued Genie, the manufacturer, they sued the electric company because of a defect in design, saying that it was unreasonably dangerous because it shouldn't have been possible for them to do what they did. And the jury actually agreed and said that the product was unreasonably dangerous, and the appellate court agreed with the jury. But it got to the Supreme Court of Texas, who disagreed. They overturned the jury verdict and said that Genie was not liable. And I think the amount in question was $1.3 million here. But they basically said that the product was not unreasonably dangerous because thousands and thousands of units had been sold, and similar injuries hadn't been happening. It's only because of the intentional misuse of the product, ignoring the safety warnings and doing something unreasonably dangerous with it, that the injuries occurred. So the court did not hold Genie Industries liable. This case could have gone different ways depending on which state you're in, and the attitudes there and the laws there, but that's how this case turned out. So the crashworthiness doctrine is a special strict liability theory that applies to automobile manufacturers, with the recognition that if somebody gets into a car accident and is injured, oftentimes it's not because of the objects outside colliding with your body, but your body colliding with things that are already in the car. Whether that be a steering wheel or dashboard or anything else flying around the inside of a car when an accident happens. So they apply the crashworthiness doctrine, which imposes a duty that manufacturers have to consumers, saying that they have to design automobiles taking into account the possibility of a second collision, and that the possibility of harm by the body striking something inside the vehicle in an accident has to be taken into consideration. So that just applies to automobile manufacturers. A failure to warn. This is another way that somebody could be held liable, a business could be held liable, manufacturer. It occurs when a manufacturer does not place a warning on the packaging of products that could cause injury if the danger is unknown. So now we have a duty to properly and conspicuously place a warning on the product, and that would insulate everyone in the chain of distribution if you properly put that warning on there. So again, some things are just inherently dangerous, but they're so useful to society, we're not going to outright ban them. So we just have to warn people about the danger so that they know how to properly use the product and aren't harmed. So a failure to warn is a defect that supports a strict liability action. It also supports a negligence action if we can show that the manufacturer was aware of a potential danger, but then they didn't warn people about it. Sometimes we only learn about some kind of danger after we've already manufactured and shipped out the products. And so if we learn about that danger later on, then the manufacturer still has a duty to then go try to let people know about some dangers. So we see this happen all the time when manufacturers recall certain products out of the market, saying we didn't know it was dangerous at the time. However, now we know it's dangerous, so we're going to take that out of there and either fix it or just remove it from the marketplace so people aren't hurt. I try to look around and see some warning signs. Vending machines. A surprising amount of people are harmed by vending machines every year when they're trying to rock them to either get something that didn't fall out right or they're just trying to get free stuff. So vending machine manufacturers have to put warning labels on there saying that tipping or rocking may cause serious injury or death, and just trying to keep people from doing that. Otherwise, if they didn't have that warning on there, maybe somebody wouldn't be aware of the danger, or at least their attorneys could claim that and maybe get some money out of it if somebody is harmed. This on a commercial washing machine says, warning, high spin speeds. Do not put any person in this washer. You would think that a reasonable person would not put another person in a washer, but it does happen sometimes. So we have to warn of that risk, saying that it actually is dangerous and not just funny, and somebody can actually get hurt very badly. And then another one for scrubbing bubbles, which is a bathroom cleaner. One thing that I thought was kind of interesting in the warning was, it's a little bit blurry here, but it says do not use for personal hygiene. So yeah, don't wash your body with scrubbing bubbles. It's just for like washing bathtubs and toilets and stuff like that. And then one that I thought was, kind of funny maybe, is a jar of peanuts where it says, warning, contains peanuts. You would think it would be obvious that a jar of peanuts contains peanuts, but some people are very allergic, so maybe it's a good idea to put the warning on there anyway, just so somebody who's allergic doesn't get close to it. An example case for failure to warn is Braswell versus Cincinnati Incorporated. This happened in 2013 in the 3rd Federal District. Actually, it wasn't the 3rd Federal District. It was the 10th Circuit. But okay, so the case involved a hydraulic press that was a very large commercial piece of machinery where you put a piece of sheet metal into a press. The press presses down on the sheet metal and molds it into whatever die you're pressing it into. So they're pretty common. And it's obviously a very dangerous piece of equipment because the press coming down comes at very high pressures and can cause a lot of harm to a person's body. So there was a couple safety protocols put into place. One of the safety mechanisms was the press was operated by a foot pedal, and on top of the foot pedal was a little safety gate. So you basically had to lift up the safety gate on the foot pedal to then press down on the pedal, and that prevented people from accidentally stepping down on the pedal. The other safety mechanism was that there were two pedals. So the press was supposed to be operated by two people, both of whom had to lift up on the safety gates on the foot pedal and then press down on the pedals at the same time in order to have the press come down. Okay, at the time that Cincinnati, who's the manufacturer, first sold this piece of machinery, both of those safety mechanisms were in place. But over time, the press had been sold to a couple of different companies, and by the time it got to this final company where the injury happened, those mechanisms had been disabled. So they removed one of the foot pedals so that it could be, and bypassed some of the circuitry so that it could be operated by just one pedal. And they removed the safety gate on that one pedal, so you didn't have to lift up on that to press it down. People do this kind of thing for multiple reasons, usually for usually for efficiency or speed reasons or cost reasons. So basically, they took it from a two-man machine down to a one-man machine and took away the safety gate to make it easier to operate the press. But regardless, those safety mechanisms had been disabled. So Braswell was the man who was operating the press at the time. He reached in, he saw a piece of metal that was jamming the machine, and he reached into the press to try to remove that jammed piece of metal. But in doing so, he accidentally stepped on the foot pedal, and the press came down and crushed his arm. His arm later had to be amputated. So he sued Cincinnati for failure to warn about the danger. The court did not look very favorably upon this claim, though, because they found that Cincinnati didn't do anything wrong. When they sold the machine, it was operating as it was intended, and there were warnings on the machine that still existed, even when Braswell was injured, warning about not misusing the product in some way that would cause injury. And so, when people disabled or removed these safety mechanisms, this was an intervening event for which Cincinnati could not be held liable. Moreover, the failure to warn claim didn't work because the safety warnings were still on the machine, and if they had been heeded and followed properly, then the injury would not have happened. Sometimes injuries can result of a defect in packaging. This is a defect that occurs when a product has been placed in packaging that is insufficiently tamper-proof. So in order to be careful as a manufacturer, I need to make sure that my containers are tamper-proof, or, tamper-proof is hard, but at least tamper-resistant. And the packaging should somehow clearly indicate when tampered with. So this is the reason, a lot of products you buy, especially in a grocery store, have some kind of, you buy a gallon of milk and it either has a little thing you have to peel off the lid so that somebody hasn't tampered with the contents, or maybe there's a little plastic thing that snaps off letting you know that somebody hasn't taken the lid off before. A lot of stuff that we consume into our bodies has these safety protocols on the packaging, just to let us know that somebody has not tampered with that product. So something you have to be aware of. And there's all sorts of other things that can go wrong with packaging. Maybe the packaging itself is what actually harms somebody rather than somebody tampering with the product inside. So I just have to be careful as a manufacturer to make sure my packaging is safe and protects the contents inside from being tampered with. Other kinds of product defects could be a failure to provide adequate instructions. So if there's a danger with a machine or some type of product, if the instructions that I give are not adequate, then we could be in some trouble. There's a product liability suit brought against IKEA several years ago, where people discovered that a lot of their products were easily tipped over, and people either hadn't been warned about the danger, or they hadn't been given proper instructions about how to prevent the tipping over from happening. So, after that, now if you buy a piece of this furniture, they almost always come with some kind of anchor to tether that product to the wall, so that it's harder for a child to try to climb up on it and tip it over and get hurt. So that's a kind of thing that could maybe form the basis of a failure to provide adequate instructions claim. We could also have inadequate testing of products if we're not having some safety testing prior to selling these things in public. That's the kind of thing that could open me up to liability. Inadequate selection of component parts and materials, if I'm not properly vetting or doing quality control on the component parts that I buy from other people, that might open me up to a claim. Or if there's an improper certification of the safety of a product, if I say that it meets some type of safety standard, but I haven't actually done what it takes to actually meet that standard, that can also open me up to liability. So what if somebody accuses me of some type of defect and they're suing me for product liability? What defenses do I have available to me if I think I didn't do anything wrong? There are several. We'll take them one by one, but one is called a generally known dangers defense. This is when we have certain products that are just inherently dangerous and are known to the general population to be dangerous. So manufacturers and sellers are not strictly liable for failing to warn of generally known dangers. That would apply to a negligence case as well. Not just strict liability, but basically if there is a generally known danger. So my example earlier of a knife being sharp and cutting somebody, that's probably not a product liability suit because it's generally known that knives are sharp and can cut and harm people. There have been some lawsuits recently where people try to sue gun manufacturers when somebody gets shot, or like in the instance of school shootings or something like that. And usually the defense is the generally known danger defense. It's generally known that guns are dangerous. They're manufactured that way. And that's known to the public. So thus far, manufacturers of guns have not been held strictly liable for failing to warn about those dangers that are generally known. Another defense could be a government contractor defense, where if I'm contracting with a federal or state government to produce some product for them, they're going to give me some exact specifications. And if I'm producing to the exact specifications that the government requires of me, then I'm probably not going to be liable if the product causes injury, because I made it according to their specs. And I had to, otherwise I would lose the contract. So I shouldn't be held liable for the dangers that resulted. Another defense could be abnormal misuse of a product. Okay, so I buy some product and I'm using it for something that is not what it's designed for, or I'm just misusing it in some other way, and that causes injury, then that would be a good defense to a product liability suit. So an example could be, talking about my scrubbing bubbles from earlier. That's a cleaning product that's designed to clean, surfaces in a bathroom. But if I use it to wash my body, that might cause some injury to me. That would be an abnormal misuse of a product, using it for not what it's designed for. So that would be a good defense to that kind of claim. Another defense is a supervening event. So a definition of that is an alteration or modification of a product by a party in the chain of distribution that absolves all prior sellers from strict liability. So a manufacturer or seller is not liable if a product is materially altered or modified after it leaves the seller's possession and the alteration or modification causes an injury. Okay, so to simplify that a little bit, I make a product. Let's say I'm going to sell a lawnmower. So I sell a riding lawnmower, and it's very safe at the time that I sold it. But then the person who buys the lawnmower decides they want to modify the engine, modify everything else about it to turn it into a racing lawnmower to go enter into the lawnmower races that we sometimes see here in the South. The product is no longer operating in the way that the manufacturer intended it to. It's been modified and altered in ways that could possibly cause an injury. Let's say if somebody is riding the mower and it either catches fire or they get involved in an accident or something like that and get harmed, and then they try to sue the manufacturer. It's probably not going to work because of the supervening event, modifying the engine, modifying the other parts of the mower to make it operate outside of what it was designed for. Assumption of risk is a big defense. And this is when the person knew about a risk and voluntarily chose to assume that risk. So I'm using some type of product. I am well aware of the risk of that product, and I voluntarily choose to keep using it anyway. So let's say I go out and buy an electric scooter to ride around. I'm going to be aware that there is a risk of, if I'm not very good at riding that scooter, I could tip over, fall over, and get harmed in some way. And if I'm not riding safely, maybe I get involved in a collision with another car or something. So there's all kinds of risks involved there. And the manufacturer is probably going to warn me of all of these risks. So as long as I'm aware of what the risks are and I voluntarily choose to assume those and engage in the activity and using the product anyway, assumption of the risk could be a valid defense to any kind of claim later. Another defense is the statute of limitations. So this is a time period from the point of injury to the point of me bringing a lawsuit. So if I don't bring the lawsuit within that statute of limitations period for product liability cases in North Carolina, that's 3 years. That will vary from state to state, 3 years here. So if I don't bring my lawsuit within that period of time, then I'm no longer going to be allowed to bring it, or at least I can try, but it'll get thrown out because of the statute of limitations. A similar concept is the statute of repose, which again, I have to bring a lawsuit within a certain amount of time. But instead of a statute of limitations is when the time period between the injury happening and me bringing a lawsuit. Statute of repose is the time period from which the date was first sold to when the lawsuit is brought. So this is a key difference because somebody may have bought a product and then put it up in their attic or on a shelf, and it sat there for years and years and years. And then I finally pull it down off the shelf and start to use it. You know, what's a reasonable time to expect, somebody to have between buying that product and using it and getting injured where I can bring a lawsuit. And in North Carolina, we settled on 12 years as being the statute of repose for a product liability lawsuit. A case example for a supervening event is Cummins versus BIC USA Incorporated. In this case, we had a 3-year-old child who was seriously burned by a cigarette lighter. When we dig into it, we find out that the father of the child, the one who bought the lighter, had a habit of removing the safety device on that lighter that's designed to prevent kids from using it. He removed it because it made it easier for him to use the lighter, and then his kid got a hold of it and used the lighter and got harmed as a result. They sued BIC USA, the manufacturer of the lighter, and the court found that the removal of the safety device by the father was this supervening event. If the lighter had been in the condition it was in when it was sold with the safety device in place, that danger wasn't there. But the supervening event of removing that safety device by the father would relieve BIC USA of liability. Additional defenses, depending on which state you live in, it's either going to be a contributory negligence state or a comparative negligence state. Contributory negligence is available in a minority of jurisdictions. However, in North Carolina, we are one of those minority jurisdictions. The basic idea is that if we can prove that the plaintiff, that if we can prove that I contributed to my own harm, then I can't recover from the defendant, even if the product was defective. So they find that maybe I was aware of it and I chose to use the product anyway, or maybe I should have been aware that something was wrong. Maybe another reasonable person would have understood about the danger and wouldn't have got harmed, but I did. So if we can show that I contributed in some way, then it's much, much harder for me to actually recover any kind of damages. However, if I live in a comparative negligence state, which majority of jurisdictions are in, we look at proportional distribution of fault. So we might find that somebody is 50% at fault and another person's at 50% at fault, and then from there we can start to decide, if the damages in question were $1 million. And we find out that the plaintiff was 50% at fault and the manufacturer was 50% at fault. Well, maybe I only get half of the million. And then the percentages can vary from there. But that's the difference between contributory and comparative negligence. The advantage that it gives businesses in North Carolina is that it's a very easy defense to use if we can prove that the plaintiff contributed in some way to their own harm. I guess the con side of that is if you're just a normal consumer, maybe it's harder to actually successfully sue a business. So whether it's a good or bad thing, I guess, is kind of up to your own perspective. That's it for this lesson. I hope you have a great day.